Hello and welcome to this fourth Five Paper Buildings webinar. My name's Andrew Johnson. It's my pleasure to introduce to you the two talks that are taking place today. The first, in a short moment, will be Jonathan Kaplan, Queen's Counsel, talking about some perspectives from his practice in the Far East on money laundering. And he'll be followed by Dr. Aparna Rao, talking about what lessons can be learned from the High Court of Australia case of Cardinal Pell in this jurisdiction. Before we begin, you should see on your screen a question and answer panel along the right hand side. Please do feel free to submit any questions you have as we go along, and we'll try to answer a selection at the end of the talks. It's now my pleasure to introduce Jonathan Kaplan, Queen's Counsel.
Well, good afternoon, and thank you for, I suppose, tuning in. And I suppose money laundering is as good a topic to talk about on a wet lockdown afternoon as any, but I hope to give it a bit of spice by talking about the Far East and some perspectives, at least I've had there, on the issue of money laundering. And the focus of my talk will really be looking at some cases in Hong Kong and one in Brunei that I think are useful to all of us for reasons which I'll explain in a moment. I think one of the reasons for choosing this topic is, first of all, I hope it's interesting that we learn a little bit about the legal systems and money laundering jurisdictions, money laundering provisions in those jurisdictions. Firstly, I think because, or at least I hope you'll find them interesting. Second, practically because money laundering cases tend to have cross-border elements, and it's becoming more important to know how other legal systems deal with part of the same criminal conduct that we may be looking at here in the United Kingdom. And thirdly, because whenever we get out of this pandemic, I suspect that we all would be interested in expanding our work beyond the United Kingdom, and hopefully to looking at and encouraging work from foreign clients and foreign lawyers. And that's certainly something which I believe is reasonably feasible for both the bar here in London and for solicitors. Can I just then begin with a word or two about obtaining work in Asia, and that is whether as a barrister or as a solicitor. And I would say that the prospects are still reasonably good for us to work in Hong Kong. I think Malaysia and Singapore are relatively closed from the point of view of court work, but from the point of view of advisory work for both counsel and solicitors, there is opportunity. I think in Hong Kong, which is a major international financial centre, where there are already many UK firms either practicing in their own right or having some loose or more formal association with local Chinese firms, there is much more opportunity for counsel at all levels in advisory work, and indeed for firms of solicitors, and real opportunity for leading counsel to seek admission to appear in court. There is quite a lot of fraud work, money laundering work, and other financial crime. And whilst it's difficult to estimate, I would think about 30% of all applications for admission by English Queen's Counsel succeed through the Bar Council and the Department of Justice. I think there's only been one instance of junior counsel who has been admitted to appear in court in a criminal case. But as I say, there is still plenty, I think, of advisory work. Of course, arbitration work is completely separate. No admission procedure is required for that because it's working completely outside the court system and the legal ordinance provisions. In Brunei, which is a much smaller jurisdiction on the island of Borneo, there's lots of potential for cooperation with local lawyers, but probably little prospect, I think, of court work, certainly at the moment. Now, what I want to focus on, having made those introductory remarks this afternoon, is money laundering, particularly in Hong Kong, and to conclude a little bit in Brunei. And I want to look at some recent developments in principally 3 or 4 cases in Hong Kong, and one significant, at least I hope factually interesting case, which happened in the High Court in Borneo last year. So I want to start with Hong Kong. And can I just make a few comments about Hong Kong? As you'll know and recall, the United Kingdom handed back Hong Kong to China in 1997. And the Sino-British Joint Declaration provided for what has been called one country, two systems for a period of 50 years. That is to say, one country, People's Republic of China, two systems, namely the system of Hong Kong, which is a special administrative region now within China, and the mainland or the rest of the PRC. And the legal system in Hong Kong is quite distinct from that in the rest of China, and it is comprised mainly of 3 elements. The first is the basic law, and I'm going to come to that in a minute. You can see it. Can we have it? I think it's on our screen now. The first page of the basic law, which is equivalent to a constitutional document. The second is common law and equity, and that's our common law, or the common law world and equity. And the third element is legislation, and the Legislative Assembly in Hong Kong is LegCo. They produce ordinances rather than acts of parliament, but many of them follow or are based on UK acts of parliament and are pretty familiar to us all. Now, can we just look, please, at document 1? It's the basic law. That's the cover. Can we go to page 2? And this is the beginning of the articles in the basic law. If we were to look at Article 2, you can see that the National People's Congress authorises the Hong Kong Special Administrative Region to exercise a high degree of autonomy and enjoy executive, legislative and independent judicial power, including that of final adjudication, in accordance with the provisions of this law. So that sets out the one country, two systems principle for Hong Kong and China. And then if you go to Article 5, please, you can see in rather colourful language, the social system and policies shall not be practiced in the Hong Kong Special Administrative Region, and the previous capitalist system and way of life shall remain unchanged for 50 years. So that means from 1997 through to 2047, we operate under the status quo. And if we can go to the next page, please, which is the, if you go to the next page in our illustrations, Article 8, the laws previously in force in Hong Kong, that is the common law, rules of equity, ordinances, subordinate legislation and customary law, shall be maintained except for any that contravene this law and subject to any amendment by the legislature of the Hong Kong Special Administrative Region. So what Article 8 is saying is that Hong Kong remains a common law jurisdiction, even though it's part of China, right through to 2047. Now, in the course of, that's the basic law, in the course of last year, you will have seen large-scale civil unrest and protests in Hong Kong. And if we go to the next illustration, Not that we necessarily need to see it, but we can remind ourselves there is an illustration of large-scale civil unrest on the streets of Hong Kong, and that was in some cases tragically quite violent and pretty unknown in Hong Kong since handover. And it was termed by the Western media and many Hong Kong students as pro-democracy protests. Now, it's not my function today to have any political element to what I'm saying, but so insofar as that relates to the legal perspective, which we are looking at the moment, and just about before we launch into money laundering, to a limited extent, it's correct that it was pro-democracy, but really only to the extent that it was a call for greater involvement and a larger right to vote for the chief executive of Hong Kong, currently Carrie Lam, and for some members of the Legislative Assembly. But it was largely, if I may say so, incorrect, because Hong Kong already has a very huge slice of democracy. You've seen the common law position preserved in the basic law. There is also a Bill of Rights, which LegCo has enacted, which gives freedom of assembly, freedom of thought, etc., etc. There is a strong and independent judiciary, and there is a separate legal system, as we've explained, one country, two systems to the rest of China, and the application of the common law. So in a way, these protests, I suggest, are more, or were more, a rally for independence from China in 2047, as well as a rather complicated debate about a proposed new extradition law between Hong Kong and China, which in fact has now been scrapped. So a very brief look at, therefore, how we come to have one country, two systems, and some local reaction to extradition law and the advent of 2047. The legal system in Hong Kong, as far as criminal work is concerned, is not that different, or in some ways it is markedly different from here. Work begins in the magistrate's court. It then goes up for trial to the district court, which is judge alone, and the vast majority of criminal work is judge alone in the district court. But some exceptional cases, some really complex fraud cases, complex drug cases, and other cases of high profile or particular requiring a particular attention from a High Court judge, do go to a judge and jury in the High Court. From there, whether it's the District Court or the High Court, it goes to the Court of Appeal, and then to the Court of Final Appeal, which is their Supreme Court. And the Court of Final Appeal is presided over by the Chief Justice. We're on the third Chief Justice, the second Chief Justice since handover, about to have a third in January of next year. And he sits in the Court of Final Appeal with 4 other Court of Final Appeal judges, and one member of that 5-court panel is almost always a judge drawn from overseas. And can we go to the next illustration? This is the current list of overseas non-permanent judges, and they're pretty distinguished, if I may say so. A lot of names you will see and are familiar from the Supreme Court or House of Lords in London. Not just London, but because Hong Kong is a common law jurisdiction, you will see on the top line Murray Gleeson, former Chief Justice of Australia. You'll see on the third line down, and on the right-hand side, Mr. Justice Spiegelman from the High Court in Australia. We then replicate, those aren't twin brothers of the judges on the bottom left, on the top right, it's just that we've carried them over to the next page. You'll see Murray Gleeson somewhere there. I've lost him myself at the moment, but I know, oh sorry, I better refer to him. There's Robert French, who is a former Chief Justice of Australia. There is Charles Gummow from the High Court of Australia. There's Beverley McLaughlin, former Chief Justice of Canada, and our own Baroness Brenda Hale. So a very distinguished panel of judges who sit as the fifth wheel, I won't say a cog, but the fifth member of the Court of Final Appeal. And I do urge you, when you're looking and researching for a legal point, not to overlook the Court of Final Appeal, because their judgments are very, very illuminating, and they deal with issues that are very familiar to us, common law issues, statutory constructions which are very similar to ours, and they frequently in the course of their judgments cover the common law position in Australia, New Zealand and Canada, and are very, very helpful judgments to cite, or at least to do your research from. And after that rather lengthy introduction, and so to money laundering. Now, we might remind ourselves of the position in the United Kingdom. Our principal money laundering provisions are contained in sections 327 to 329 of POCA, which of course replaced the Criminal Justice Act 1998, and the Drug Trafficking Act 1994. And essentially here you commit a money laundering offence if you deal in property when you know or suspect that that property is criminal proceeds. And so the prosecution has to prove actual knowledge or actual suspicion, which they can do from circumstantial evidence. And a key decision in the United Kingdom was, of course, the case of Montilla in 2004, which decided that the prosecution must prove as a fact that the property in question was criminal proceeds. And I'm now going, if we can, to the next illustration, which sets out the cases I'm going to refer to in the course of the remainder of my talk to you. And Montilla, of course, decided that prosecution must prove that, in fact, you were dealing with criminal proceeds. They must prove a predicate offence. They don't need to prove specific criminal conduct, but they must prove a predicate offence. And in reaching that decision in 2004, the House of Lords had regard not just to the legislative history of the provisions, but to the underlying international agreements which this country was a party to, including the Vienna Convention and various EEC directives. And they concluded from looking at those international agreements and Parliament's intentions for the United Kingdom that it was necessary to prove actual criminal proceeds were in play. Now, in Hong Kong, which of course is a major financial international centre, money laundering is a major concern. The relevant provision there, if you can go to the next slide, please, is section 25 of the Organised and Serious Crimes Ordinance. And we need only look at subsection 1, where it tells us that a person commits a money laundering offence, and this phrase, if knowing or having reasonable grounds to believe that any property, in whole or in part, represents any person's proceeds of an indictable offence, he deals with that property. So immediately we can see that there are some important differences between Hong Kong and the United Kingdom. Firstly, the actus reus of this offence in section 25 is that you are dealing with property. It doesn't say dealing with criminal property. It ends, he deals with that property. The offences in POCA expressly say dealing with criminal property. Secondly, it doesn't say know or suspect. It says know or have reasonable grounds to believe. Knowledge, of course, presents no difficulty, but the question of reasonable grounds to believe has proved in this statutory context a legal minefield in Hong Kong, and has given rise to 4 major cases in Hong Kong in the quarter-final appeal over the last few years. And the issues raised, although not specifically relevant to our money laundering offence, about what reasonable grounds to believe means, has very great relevance to that phrase in other statutory contexts. Now, in 2016, the quarter-final appeal considered the money laundering conviction of Carson Young. Can we have the next slide? There he is, holding up a Birmingham City shirt. He actually trained as a hairdresser and had a barber shop originally in Kowloon, appropriately named Vanity. He then went on to deal in penny shares and to set up a business in Macau. But mysteriously, between then and 2009, when he made a successful bid for Birmingham Football City in about the sum of, I think, £80 million, he seemed to have that amount under his control. But 2 years later, in 2011, he was arrested for money laundering. And the quarter-final appeal in Carson Young's case had to consider 3 key questions in 2016. They firstly considered or reconsidered the Montilla point. Was it necessary in Hong Kong, which was party to the same international conventions as the United Kingdom, for the prosecution to prove a predicate offence? Secondly, when considering statutory context, reasonable grounds to believe, to what extent are the defendant's thoughts, beliefs and perspectives relevant? And finally, does the rule against duplicity operate in money laundering so that you have to charge each act of dealing or deposit separately, or can you all roll all of those acts up if they're part of one course of criminal conduct into one count and charge them all as one offence? Well, moving on swiftly, because I can see my time is running fast. As far as the Montilla point is concerned, the quarter-final appeal took a different solution to the House of Lords. They looked at the Vienna Convention, to which they were a party, but they decided, seems to be the case, that the Vienna Convention had given considerable discretion to parties to decide how much stringency they wanted to inject into their own domestic offences. The quarter-final appeal decided not to follow Montilla. It decided that Hong Kong policy was not to require the prosecution to prove that the proceeds were in fact criminal proceeds. Obviously, if you're charging knowledge and you knew they were, well, then that's integral to the offence. But if you're charging reasonable grounds to believe, then it's enough to charge reasonable grounds to believe without proving that they actually were criminal proceeds. Now, what that means led to 2 further cases in the Court of Final Appeal. But I should just say this: there was an underlying policy to the Court of Final Appeal not following Montilla, and that was that most predicate offences which gave rise to money laundering in Hong Kong coming through the Hong Kong banks probably had occurred outside Hong Kong, and the view was taken by the legislature that it probably would be difficult to prove those offences in a Hong Kong court. Now, staying with reasonable grounds to believe, the obvious question then arose, well, what does that mean in practice? And that's very relevant for us in other statutory contexts, but in money laundering Hong Kong it was critical. And the answer that was teased out in a number of cases, culminating in a case only last year in the case called Muldihar, was this: reasonable grounds to believe is a combination of an objective and subjective test. The subjective part of it is to ascertain what the defendant knew or would have known at the material time about the relevant facts, and to put into that mix what his perceptions, beliefs and perceptions were. The objective test is to decide on the basis of that information what a reasonable man would have made of it. On the basis of that information, would a reasonable man have concluded that the property in question was criminal proceeds. You don't have to prove it was criminal proceeds, but what would a reasonable man have made of what the defendant knew or perceived? And so the ultimate perspective is not what he actually believed, the defendant, but what the perception of the reasonable man is based on the relevant material. Also in the case of Muldeha, the Court of Final Appeal considered whether willful blindness was relevant to money laundering. They concluded it was, and that it could help the prosecution to prove knowledge, that the defendant knew, because if you turn a Nelsonian eye, that is the equivalent of knowledge, but it's not relevant to reasonable grounds to believe. As far as the other aspect is concerned, namely the question of duplicity, I think the position really has ended up the same as in England. It would be ludicrous to have to charge every deposit or every dealing if it's part of the same course of conduct from the same source of funds as a separate offence. You'd end up with hundreds of offences on the indictment. So as long as it is part of the same course of criminal conduct and it occurs within or about the space of a year, then that can be charged as one offence, because it isn't unfair and it can be viewed as a single offence. So enough of Hong Kong, and in the 2-3 minutes left to me, I'm quickly going to go to Brunei, which is about 1.5 hours away, and here you will see two individuals, and I prosecuted them actually last year. You might wonder who they are. They were in fact judges in the High Court in Brunei. The gentleman on the right says former senior magistrate. He was also a district judge dealing with money laundering cases and sat in capital cases with the Chief Justice. The lady on the left is a senior registrar, was a senior registrar, and a deputy official receiver. And the offence in that case arose, amazingly, she, as deputy official receiver, was in charge of accounts of people who'd been adjudicated bankrupt, and accounts were opened whereby they would pay back monies under a court supervised system to their creditors. And undetected for at least 15 years, she was able to withdraw in cash many millions of Brunei dollars, about 15 million or so dollars, which is many millions of pounds, in large sums of money. And she and her husband, gentleman on the right, were the beneficiaries of that large amounts of cash. Not all of it was traced, buying cars, a luxury lifestyle, hundreds of Chanel bags and many other items. But the issue arose really as to how this course of conduct involving two judges could be contained within a manageable indictment, and whether there could be a trial in Brunei. It's a very small place. They do have visiting judges, and a former judge from Hong Kong was brought in to conduct the trial. There was a criminal breach of trust against her for withdrawing this cash, which was under her control, for no official reason whatsoever. And there were money laundering charges against them both for dealing with the cash. In Brunei and Singapore, they still have the largest denominational notes, $10,000 notes, which are the equivalent of about £5,000. And we were able to trace those $5,000 notes passing through their hands into their accounts to purchase luxury cars or items, or even to be spent on large shopping sprees here in London, and in other ways in which they used those funds. And they were convicted by judge alone after a lengthy trial, and she was sentenced to 10 years. That sentence is under appeal by the prosecution. They're appealing their conviction, and he was sentenced to 5 years. I mean, in Brunei, it's interesting to note that the offence is a bit of a combination of both. You commit a money laundering offence if you deal with property knowing or having reasonable grounds to believe or suspect. So it pulls together both the UK and the Hong Kong offence that it is criminal proceeds. Again, it's not necessary to prove in Brunei a predicate offence. But it was such an unusual case involving judiciary, I suspect if that money went missing from court accounts here, we would probably know about it much quicker than after 15 years. But anyway, it was an unusual case, and I thought, as we were talking about money laundering, it might enliven an otherwise hope not too dull discussion. So I think I've just slightly overrun my time. And there, yes, finally to conclude, nothing like Southwark Crown Court, a very nice court building in Brunei, which is their High Court, and very well equipped, very technologically up to date. And it's nice to see that some jurisdictions actually do invest in their court buildings and in their technology. And so I think we can congratulate Brunei as well as Hong Kong on doing that. And thank you very much. That's it, I think, for the moment.
And thank you for the 2 questions we've had come in. I'm going to go to Jonathan first, if I may. And Jonathan, the question that's been asked of you is this: do you need language skills to assist in the Far East? And how would you go about building relationships with firms there? I think, Jonathan, you're still on mute at the moment.
There we go.
Thank you.
Thank you for the question. No, you don't need language skills. In Hong Kong, there are, in fact, courts which deal with some cases in Cantonese, not Mandarin, which is the mainland language. But there are many English judges, many English or barristers who only speak English from Australia, South Africa, Canada, England, who are admitted and practice full-time in Hong Kong, and therefore they only do English language work. There is a division of the Court of Appeal, and of course some High Court judges and some District Court judges and some magistrates who are do conduct Cantonese trials and hearings, but obviously somebody who can't speak that would never be assigned to that case. So it's not a necessity at all. Similarly in Brunei, no, the language is essentially English. How do you develop contacts? Well, I would say that you could write for Hong Kong journals. You could, there's ways of joining international law conferences. I'm not sure who asking the question is a barrister or a solicitor. You could join international legal conferences or seminars that are held in Asia, where there will be Hong Kong delegates. You could actually look out for one in Hong Kong, go there. They're very keen to use English lawyers. Obviously they've got a very strong local bar, but there is certainly work for silks in court, and there's work for juniors in advisory capacity, and for solicitors I would unquestionably be looking to, if I had a solicitor's firm, to probably have some kind of loose consultancy or liaison with a local firm who could market us as being an extension of themselves, and would not be looking to, wouldn't be worrying about us stealing their clients, and who would look to the English firm to be able to add to their experience by having done work in the UK and being more experienced perhaps in some areas than the local Chinese firm. So plenty of opportunity.